Good morning. Today I'm holding what I hope will be the first in a series of hearings on various provisions of the Lacey Act. It is appropriate to start this oversight by closely examining the most significant and some would say contentious changes to this act in almost 40 years. The expansion of the Lacey Act to include all plant and plant products was signed into law on May 22, 2008. The full House was never given the opportunity to debate or amend the 2008 Lacey Act amendments. The language was added in the Senate as a floor amendment to the 700-page 2008 Farm Bill. These provisions are costing millions of dollars in compliance costs and subjecting Americans to literally thousands of foreign laws, regulations, and decrees. It is now 5 years later, and it is time to examine whether this law has had its intended effect of reducing, if not stopping, the importation of illegally harvested timber and products made from such wood. It is also time to ask, what is the benefit of having U.S. importers and small businesses fill out tens of thousands of plant and plant product declaration forms at a cost of hundreds of millions of dollars, when these forms are not shared, have not been used to initiate a single investigation, and not even being reviewed? There must be a better way to collect this information in a more effective manner. All right, we're now ready for our second panel of witnesses, which includes Mr. Travis R. Snapp, Chief Operating Officer of Benchmark Holdings.
Good morning, Mr. Chairman and members of the committee. My name is Travis Snapp, and I'm the Chief Operating Officer at Benchmark Holdings. I'm pleased to be testifying on the Lacey Act before the House Subcommittee on Fisheries, Wildlife, Oceans, and Insular Affairs today. I'm here as a member of the International Wood Products Association. IWPA is the leading international trade association for the North American imported wood products industry, representing 200 companies and trade organizations. IWPA has also been active in the Lacey Act Coalition, a broad group of domestic manufacturers, retailers, and distributors from small family businesses to multinational corporations that are greatly impacted by this law. My company, Benchmark International, has certainly been impacted by the Lacey Act. Originally founded over 60 years ago as Pittsburgh Testing Labs, Benchmark International is one of the oldest wood product certification and testing agencies in operation today. We provide independent third-party certification of wood products, materials testing, research and development, international regulatory compliance program management, and engineering services. I'd like to speak to you about my professional experiences with the Lacey Act as a product and process certifier. I first became involved with the Lacey Act in 2008 when Congress amended the statute to include plant and plant products. Benchmark International immediately began working on a proprietary Lacey compliance verification program. This LCV program is designed to provide independent third-party audits to assist manufacturers and importers in demonstrating due care, which the Lacey Act defines as the degree of care that a reasonably prudent person would exercise under the same or similar circumstances. Under this program, Benchmark International offers the necessary training, detailed record keeping, on-site investigation, and verification to ensure that a company has exercised due care when sourcing raw materials for products or importing finished goods from abroad. Our program gives downstream customers a high degree of confidence in the products they purchase. Since Benchmark began offering the LCV program in 2009, we have had 33 manufacturing facilities from around the world request to enroll in our program. However, due to the complexity of supply chain and the broad scope of the Lacey Act, I've been forced to turn 29 of these 33 facilities away from our program. To be very clear on this point, this is not to imply that there is illegal material running rampant in supply chains. Rather, it demonstrates that supply chains are complex, making it difficult to identify every chip of wood used to produce a finished good to the extent the Lacey Act requires. Several manufacturing facilities, if enrolled in our program, would have required 2 to 3 full-time staff working 40 hours per week just to keep track of the raw material stream. This complexity is not confined to the manufacturing facilities that have approached me. Companies in the United States and around the world utilize raw materials from a variety of sources, both domestic and foreign. It isn't just the raw materials that make it difficult to certify to Lacey. The vast number of foreign laws, included under Lacey are unmanageable in scope. Benchmark International contracts 6 legal firms overseas who track only the laws related to wood exporting, processing, concessions, and cutting in a mere 6 countries. That limited scope alone accounts for over 1,000 plus laws that U.S. companies have to comply with when importing wood to the United States. It has cost my clients upwards of $300,000 since 2009 when we began our program. These 1,000 laws and regulations do not scratch the surface of what the Lacey Act's true scope includes. When a speeding ticket for a truck transporting logs, an overweight vehicle, or a customs issue between 2 governments are all considered Lacey Act violations, from my perspective as a certifier, that is unreasonable and unachievable. My recommendation to this subcommittee is to clarify the scope of the Lacey Act as it relates to plant and plant products. This can be done by amending the 2008 to narrow its scope, by compiling a list of all foreign laws that fall into the Lacey Act, or by a combination of both. It is imperative that the scope of laws be narrowed to those that actually deal with plant and plant products, that the concept of contraband be clarified so that businesses may have their day in court, and that pre-2008 material be exempted from the Lacey Act declaration requirement. Thank you, Mr. Chairman and committee members, for the opportunity to appear before you today. I stand ready to answer any questions you may have.
Mr. Snapp, could you more fully explain how you had to turn away that 29 companies that you talked about from the Lacey Act compliance verification program?
Thank you, Chairman. I'd be happy to answer your questions. The complexity of supply chains stretch to the product itself. So if you're looking at an engineered panel, an engineered matte form panel, you have multiple forms of raw material feeding that production facility. So you can have residuals from a sawmill, you can have actual timber harvested. All of those products can come from a very large area. So tracking back downstream to where those materials originated from becomes problematic at best. If you have a specified concession, which is what our current program enrollees have, it's much easier. But if you don't have a specified concession and you are purchasing raw materials from secondary suppliers who may have purchased that material from a third-tier supplier, the ability to backtrack where that material came from is nearly impossible without a very large workforce.
Okay. Well, that then leads to the second question. What is your annual cost to have 6 legal firms on retainer to keep track of foreign laws?
The program that we developed using the legal firms overseas in the country of origin where the material is initially harvested at is a front-loaded cost because we have to use the attorneys to isolate, identify all of the relevant laws before the program begins. So the initial 2 years, the average cost per facility was ranging between $25,000 and $40,000. On an ongoing maintenance basis, now that we have identified those laws, the legal firms actually provide oversight and advice on any changes. That cost averages the mills $10,000 to $15,000 per year.
And who ultimately pays that cost?
The clients pay that cost, sir. And that cost is technically carried down to the end customer, but we've seen significant difficulty for end customers to justify a higher price on a commodity product based on that investment in legal and our services.
So if the end user, the customer, the retail customer, simply can't afford or is not willing to pay for that product, then what impact does that have on jobs?
On the jobs specific to the United States, sir?
Yes.
You see a higher cost going into what we call reman facilities who utilize cut lumber, they utilize engineered panels. If their base cost increases, their finished product cost increases. So if their finished product cost increases, then the consumer price is going to increase. You have alternative products that come from overseas in finished product form that don't have those costs associated with them, which can further undercut those U.S. produced products, therefore putting more pressure on U.S. jobs.
So the net result is transfer American jobs to foreign countries.
Correct, sir.
I would like to thank you panel for your valuable testimony and contributions today. Members of the subcommittee may have additional questions for the witnesses, and we ask you to respond to these in writing. The hearing record will be open for 10 days to receive these responses. Before closing, I ask unanimous consent to submit for the record a Congressional Research Service report on the Lacey Act, compliance issues related to improving plants and plant products, a statement by the American Forest and Paper Association, and a statement from the World Wildlife Fund. As I indicated at the beginning of this hearing, this is just the first in a series of hearings on the Lacey Act, and it's likely that a second oversight hearing will be held within the next 2 months. I want to thank members and staff for their contributions to this hearing, and thereby being no further business, the subcommittee is hereby adjourned.